So welcome back to our October fall series. I don't know, it really heads into winter, but it's Thursday. So we're at Thursday forms. Today we're talking about the TOPA. So if you're like, Amy, that's not the TOPA that is on the screen, you are correct. That is the residential purchase agreement. So I'm just showing you on the residential purchase agreement where the TOPA comes into play. And if we have additional time, we may touch on the tenant key and lockbox addendum, which actually goes with the listing agreement, as well as the tenant estoppel certificates. So, but anyways, here on section M is where the residential purchase agreement talks about possession of the property. The first is time of possession upon notice of recordation or on date specified as applicable in 3M2 or attached TOPA. So that's the default. Okay, so it goes down there to that. You can also specify a specific time, or you could specify, it says 6 p.m., which would be the end of the day, basically, or another time on date specified as applicable, or in 3M2 attached TOPA. Second option here is the seller occupied or vacant units. So that's not going to apply necessarily because of the fact that we're talking about a property that is tenant occupied. So anytime there's a tenant in the property, you should include the TOPA, the TOPA. You're going to check this box here on the residential purchase agreement. Occupied units by tenant or anyone other than the seller. So if the seller is not occupying the property or the property is not vacant, then it goes to this tenant occupied property addendum. So the seller's brother lives in the property, anything like that, we would use this TOPA. And keep in mind here on the far right-hand side, it says seller shall disclose to buyer if occupied by tenants or persons other than the seller, and attach TOPA in a counter offer, if not part of buyer's offer. Okay, this is a legal requirement as part of the contract. If it's not a seller occupied or vacant property, you get a TOPA form. Okay, so now let's hop down to the TOPA. It's the tenant occupied property addendum. And so this is used anytime you're selling tenant occupied properties for 1 to 4 units. Over 5 units, this form does not apply. This is the car form TOPA. It was updated in the June of this last year. Keep in mind that we're coming up on another forms update at the end of the year. They like to mess with us at the end of the year. But this is an addendum to the purchase agreement, or it might be counter offer if the seller hadn't disclosed or the buyer hadn't included that as part of their offer. You'd put the counter offer 1, or it could be other. Then make sure you put that date. Again, this is going to be the date in the upper left-hand corner of the residential purchase agreement, that one that is printed on that form. Put in the full property address. Every week I cover this. Make sure you put the suffix for the street, right? So it's 123 Sample Street, Court, Way, Drive, Parkway, whatever else, circle, whatever it is. Make sure you include the entire address, because there are multiple street names and numbers that match. Oftentimes you might have a 123 Sample Street and a 123 Sample Court. So be specific. Make sure you put the city, state, and zip code. Buyer's names and seller's names should go on the line. Okay, that's the same of every other form that we fill out the top of. Buyer and seller are hereby referred to as parties. For the purpose of this tenant occupied property addendum, tenant shall mean any adult person other than seller who is occupying the property, whether or not paying rent, right? Anybody who's in that property that's not the seller. Okay, section A. Or sorry, 1A would be tenants to remain in possession, right? That's our first option. Hey, the tenants are going to remain in possession after the close of escrow. Buyer shall take the property subject to the rights of the existing tenants and under the terms and conditions specified in paragraph 2. Okay, so that would be tenants are going to remain in possession. 1B is the property to be delivered vacant. So if the tenants are going to be out before or upon the close of escrow, we would check this box here. Otherwise, it defaults to tenants are going to remain in possession. The property or unit. So if you got a 2-unit, like a duplex, and the buyer intends to occupy one of the units, but not the other one, then we would specify here which unit should be delivered vacant. Okay, so it could be that kind of 1 A and B apply, even though it says or. So if you have multiple units there, you would want to specify that. So the property or units shall be delivered vacant without existing tenants is B1. B2 is if seller, after exercise of good faith attempts and subject to applicable law, is unable to remove existing tenants by close of escrow, or we would check this box here. So our default is by close of escrow. Okay. But if you want the tenants out prior to the close of escrow, to make sure that we don't have any issues with the tenants not vacating, with any damages to the property, so that the current seller can settle up deposits before the close of escrow, that might be a good option, that the tenant actually has to be out before the close of escrow. You might want to check that box there 5 days prior to close of escrow. Buyer may cancel this agreement, and buyer's sole remedy shall be the return of deposits and buyer's reasonable out-of-pocket expenses for inspection reports and appraisal fees under the agreement. Or buyer may elect to proceed with the transaction with the tenant in possession and waive the claim for other damages or compensation arising out of the tenant's remaining in possession. Okay, so 1 is just outlining, hey, it's to be delivered vacant. 2 is saying, hey, when are the tenants going to be out? Are they going to be out by the close of escrow or before the close of escrow? Check your box. And then keep in mind here that it's saying that, hey, the buyer is due the deposit and any reasonable out-of-pocket expenses for inspection reports, appraisal fees under the agreement. Okay. Now, keep in mind too, this is really important, that if the tenant has been occupying that property, whether they pay rent or not, ultimately longer than a year, they are due a 60-day notice before to vacate the property. Less than a year requires 30 days, unless the lease agreement specifies differently, but generally under a year is 30 days. If they've been there over a year, it's 60 days. So just kind of keep that in mind when you go to write that offer, so that you can write the close of escrow appropriately based on whether the seller has provided notice or not at this point. Okay, super important little fact there. And keep in mind here that it says, hey, your 2 options are buyer can cancel the agreement, or buyer could elect to proceed with the transaction with the tenants in possession. Okay, so it's outlining those are the 2 options. Keep in mind, there's always a third option, that we could extend the close of escrow. Okay, so we can extend that. So the buyer doesn't necessarily have to cancel. They don't necessarily have to close with the tenants. The buyers, instead of canceling, could say, hey, let's extend the close of escrow because we don't want to close with those tenants in place. Okay. Number B3 is seller within 5 days prior to the close of escrow shall deliver to buyer the names of all adult occupants residing in the property other than the seller who are known to the seller, or the following are the names of all adult occupants other than the seller that are known to the seller, right? So it's just saying, hey, within 5 days prior to close of escrow, seller's delivering that information to the buyers. So if the tenants have not yet vacated the property, buyers are getting that information. Even if, pursuant to the agreement, seller remains in possession after the close of escrow, no tenant shall remain except, right? So if we have in place that there's going to be like a SIP in place or a RLAS in place, the residential lease after sale, or the seller in possession after the close of escrow, it's saying, hey, the seller can remain, but tenants should not remain except, and we would put their names there. Okay. Any questions on section 1? I do also have the chat box open, so if you don't want to unmute yourself, you can throw any questions that you have in that chat box.
No questions. Thank you, ma'am.
No questions. You're welcome. And keep in mind too, that if you do have questions as we continue on, you can always just unmute yourself and tell me you have a question. I won't consider it rude. So that's section 1. It's either, hey, they're remaining in possession, or it's to be delivered vacant. If it's delivered vacant, here are the terms under that. Section 2 is tenant remaining in possession, additional terms. Now, also keep in mind that if a tenant has a lease agreement with a seller and the seller is selling the property, the lease agreement remains intact even if the seller sells the property. So that doesn't negate the lease agreement that tenant has just by selling the property. The tenants actually get sold with the property. So if you have a seller who has tenants, who has an investment property that they want to sell, and they have tenants in that property, and the lease agreement continues on, like maybe it's another 6 months or so, it's an important thing for the seller to have a conversation with those tenants to see, number one, oftentimes what we do is we offer to see if the tenants are interested in buying the property, right? Easiest way to sell a property oftentimes is, hey, tenants, do you want to buy it? You've been living here. Otherwise, you're going to end up having to move at some point or getting a new landlord. They may not be very nice. We have no idea. So do you want to buy the property? And then you can negotiate that with the tenants. Second option is, hey, tenants, you have a lease in place for another 6 months. So here's our options. We are going to sell the property, and we can either sell it with you in there, at which point you're going to get a new landlord, or if you're interested in finding a new property to live in so that you're not undergoing the turmoil of switching landlords and the potential that they're going to serve you a notice in 6 months, if you want to vacate early, we're willing to break the terms of the lease to allow you to do that. And not only that, but we'll guarantee you get your full deposit back, or maybe even your deposit plus some, to get the tenants out of the property ahead of time. Now, ultimately, tenants can say, no, we're staying here. And unfortunately, the seller has no other option but then to sell the property with the tenants in place. So those are kind of your options when it comes to the lease. It does stay with the property, even if the property is sold. All right. So number 2 is the tenant is remaining in possession. Up here, it's specified that if the tenant is to remain in possession under 1A, that we would see the additional terms and conditions in paragraph 2. So if we are doing 1B and all the units are to be delivered vacant, then all we do is do 1B. We are going to skip section 2. But tenants remaining in possession, we go into section 2A, tenant deposits and unearned rent. Seller shall deliver to buyer through escrow all unused tenant deposits, if any, and all prepaid but unearned rents, if any, prorated as the close of escrow. Seller shall disclose to buyer any tenant delinquencies. Seller shall credit buyer for any delinquent rent prorated as of the close of escrow. And what that means is, hey, if we're taking possession, close of escrows on October 19th, then the 20th on, now the buyer has become the landlord. So prorated rent means, hey, the tenant's paid rent for all of October, and the seller has that rent in possession. So we're going to take that rent, divide it by 30 days, and then multiply it by 11 days, because the 20th through the 31st is 11, and that's the remaining days for that month. And then they're going to get a credit. The buyer's going to get a credit for that unused rent. Okay. In addition, the deposits are going to transfer over as well. So that's what 2A is outlining. If the rents are delinquent, and it may just be a good idea to check this box here, if the tenants aren't paying rent, that the seller is going to credit buyer for any delinquent rent prorated as of the close of escrow, which means that, hey, seller, even if you didn't get October's rent, you're still going to pay me the amount of rent that I would be due from October 19th or October 20th through the end of the month. Okay. So it might be a good idea to check that if you don't know if the tenants are delinquent or not. 2B is government compliance, no warranty. Oh, did you have a question, Anastasia?
Yes. In that instance, can you request that those people be vacant by the time close of escrow, or do you not have that say so if they're delinquent on their rent?
Yeah, so this is a good conversation to have with the listing agent prior to writing the offer. Is number 1, are the tenants, what are they paying in rent? And number 2, are they current on their rent? So that you know, and absolutely, if tenants were delinquent on rent, you may want to write the offer checking 1B versus 1A, where the property is to be delivered vacant. And tenants not paying rent is, again, I'm not a property management expert, but generally speaking, tenants not paying rent is a breach of contract, and they can be evicted from the property at that point if the contract runs longer than the purchase agreement. That would be one of those cases where tenants could be evicted. For the most part, again, you probably want to check with a qualified licensed real estate attorney to get some input on that subject to make sure that you know what tenant rights are and what they aren't. But yeah, so you probably want to know whether they are current or not going into it before you even write the offer. But oftentimes too, this comes into play in that like distress, usually, you know, you've got tenants in place, they're not paying rent. you and the sellers want to be rid of this property, usually the property is discounted. So you're getting it below market value of what it would be if the tenant was not in that property. So oftentimes an investor is going to pick it up and they're willing to deal with a delinquent tenant and serve that notice and everything after the close of escrow and kick that tenant out, go through that eviction process. So it just depends on what your seller is willing to take on and or what your buyer is willing to take on and what information you can glean prior to entering into contract on that property. Okay.
Thank you so much.
Absolutely. Government compliance, no warranties made concerning compliance with governmental restrictions, if any, limiting the amount of rent that can lawfully be charged, maximum number of persons who can lawfully occupy the property, or ability of buyer to remove tenants from possession. Buyers advised to carefully read and consider the attached rent cap and just cause addendum, car form RCJC, which may impact buyers and tenants' rights and obligations under the law. Buyers advised that local ordinances may also affect buyer and tenants' rights and obligations. Okay, so that's your governmental compliance. Proposed changes, seller shall give buyer written notice of any existing leases or tenancies, new agreements to lease or rent, or changes to the status of the condition of the property. Proposed changes, at least it defaults to 7 days prior to any proposed changes. Okay. And then C2 is buyer shall within 5 days after receipt of notice of proposed changes, give seller notice of buyer's objection to the proposed changes, in which case seller shall not make the proposed changes. So if they were going to do a rent increase or something else, who knows what it was, they're supposed to give you 7 days prior to that, prior to making any proposed changes, give buyer notice of what those are, and then buyer has the right to object those proposed changes because ultimately they're going to go beyond and then become the buyer's problem after that. So they can accept or reject those proposed changes. And if they reject them, then the seller cannot make the changes. Okay, any questions there so far, A through C of section 2? All right, the next one is personal property included in the sale. A complete list of all personal property of seller currently used in the operation of the property and included in the purchase shall be delivered to buyer within the time specified in paragraph 14. Seller shall deliver title to the personal property by bill of sale, free of all liens and encumbrances, without warranty and condition, and as additional security for any note in favor of seller for any part of the purchase price, buyer shall execute a UCC-1 financing statement to be filed with the Secretary of State, covering the personal property included in the purchase, replacement thereof, and insurance proceeds. So this really comes into play, right? Like the seller's fridge is in the unit. Maybe they've got a laundry room in there with the washer and dryer, right? That's all personal property. Or sometimes you might be buying like a furnished rental, at which point like you've got to itemize what's in that furnished rental. So just kind of keep that in mind that they should be providing a complete list of personal property to be included. Okay, also important to ask so that you know going into it so you can include it as part of the offer if there's fridges or washers and dryers that are part of the seller's property. Section E is seller documentation and additional disclosure within the time specified in the agreement for seller delivery of the documents and subject to buyer's rights of review. Seller shall disclose, make available, or deliver as applicable to the buyer the following information, right? So this is saying, hey, tenant occupied. These are the things that are going to go to the buyer as part of this escrow period. These become part of the seller delivery of documents. Okay. Rental service agreements, all current leases, rental agreements, service contracts, and agreements pertaining to the operation of the property. So that includes not just leases to the tenant, but if they have like a service contract in place for landscaping or whatever it might be, part of those service contracts, or if they're providing internet to their tenants, a copy of that service contract, right? Super important that we continue on with the same services. A rental statement, including the names of tenants, rental rates, period of rental, date of last rent increase, security deposits, rental concessions, rebates, and other benefits, if any, and a list of delinquent rents and their duration. Seller represents the documents to be furnished are those maintained in ordinary and normal course of business. So keep in mind here, it's saying that, hey, we're delivering, like if somebody's delinquent, the length of that delinquency, so that document pertaining to that. So this falls underneath the buyer's review of seller's documents, right? So if we leave that contingency in place, if we didn't know the tenants were delinquent ahead of time, now we know the tenants are delinquent, that would be a material effect affecting the property, and the buyer could cancel based on delinquent rents if they did not want to take that on, and the tenant could not be vacated from the property, or can't think of what it's called. I've said it like 10 times today, but that's all right. Kicked out, whatever that is, of the property. And then, so, right. So, or the tenant could turn, or the buyer could turn around and say, hey, based on the information, the documents, that we request that the seller serve notice to the buyer or to the tenant in the unit based on their delinquency, right? So there's a lot of options there that could fall underneath that seller documentation and additional disclosure. Second one is not checked, income and expense. Oh, Anastasia, question?
Could they extend the close of escrow to coincide with that tenant being out, that say, hey, you know, I want you to give them a 30-day notice because they've been there less than a year. Let's base the close of escrow on them being evicted.
Yep, absolutely. You could.
Okay.
Evicted. Thank you. That was the word I was looking for. Yep, you could do that. Income and expense statements, if checked, books and records for the property, if any, including a statement of income and expense for the last 12 months preceding acceptance. That generally doesn't come into play with like a single family residence, but when you start talking like a 2, 3, 4 unit property, duplex, triplex, fourplex, right? You may want the income and expense statements as part of the transaction. So you would check that box. And 3 is the tenant estoppel certificates. Tenant estoppel certificates shall be completed by seller or seller's agent and delivered to tenant for tenants to sign and acknowledge that tenants' rental and lease agreements are unmodified and in full force and effect, or modified, stating all such modifications, that no lessor defaults exist, and stating that the amount of any prepaid rent or security deposits. Seller shall exercise in good faith to obtain tenant signatures, but seller cannot guarantee tenant's cooperation. In the event seller cannot obtain signed tenant estoppel certificates within the time specified above, seller shall notify buyer and provide the unsigned one that was provided to the tenant. If after the time specified for seller delivery of the TEC to the buyer, any tenants sign and return a TEC, that's the tenant estoppel certificate, to the seller, seller shall deliver that TEC to the buyer. So that's the tenant estoppel certificate. I actually highly recommend that you include the tenant estoppel certificate as part of a tenant occupied property where the buyer is intending to leave the tenant in place. Okay, and we can go over what that looks like as well. If you want, we should have time. 4 is survey plans and engineering documents. If in seller's possession, copies of surveys, plans, specifications, engineering documents, if any, prepared on seller's behalf in seller's possession. So if seller has any of those, they're supposed to disclose that. Permits, if in seller's possession, seller shall deliver copies of all permits and approvals, certificates of occupancy, conditional use permits, developmental plans, and license and permits pertaining to the operation of the policy, again, or the property. Again, that's if seller has those in possession. 6 is structural modifications. Seller shall disclose to buyer in writing any known structural additions or alterations to the installation or the installation, alteration, repair, or replacement of significant components of the structure upon the property. Okay, so any changes to the property. Any questions, any other additional questions on section E?
No, ma'am.
All right. Fabulous. Seller representations is section F. It's our final section, unless otherwise disclosed under paragraph 11 of the agreement or any other disclosure delivered to buyer. Seller represents that seller has no actual knowledge that any tenants has any current pending lawsuits, investigations, inquiries, actions, or other proceedings affecting the property or right of use to occupy it. Seller receives any such notice prior to the close of escrow. Seller shall immediately notify buyer. Seller represents that no tenant is entitled to any rebate, concessions, or other benefit except as set forth in the rental service agreements. And seller represents that the documents to be furnished are those maintained in the ordinary and normal course of business, and that the income and expense statements are used by seller in the computation of federal and state income tax returns. By signing below, buyer and seller acknowledge that each has read, understands, and received a copy of and agrees to the terms of this tenant occupied property addendum. And that's the end of that document. Any additional questions on any part of this document? All right. Charles?
Oh, no, I was just going to say, great explanation of each term. And thank you.
You're welcome. Absolutely. So again, this should be used anytime there is somebody who is not the seller occupying the property. Even if they're going to vacate before the close of escrow, this needs to be included in that purchase agreement. We will skip down to the tenant estoppel certificate so that you can see what that looks like. Oh, you know what? Before we jump onto that, this is the form that's attached to the TOPA form. That's the tenant occupied property addendum that we just covered, is the rent cap and just cause addendum. So state or local laws may limit the availability of certain exemptions. Check with a qualified California real estate attorney before proceeding. This is CAR form RCJC, or the rent cap and just cause addendum. The following terms and conditions are hereby incorporated and made part of the residential lease or month-to-month rental agreement dated on the property known as blank, in which blank is referred to as the tenant and blank is referred to as the housing provider. And for this, just so you know, you could always put in here like provided for information only, right? Because technically our buyer may not have the tenant's names or anything. So we're just providing this in the case that the tenants are remaining in possession so that they have the information. So you may want to like copy paste, right? So provided for information only. Rent cap, you may get caught in trouble with the transaction coordinator for that, just for the record, but that's how I would handle this. Rent cap and just cause addendum terms. With certain exemptions, housing provider may be subject to the rent cap and just cause eviction process of the civil code. Housing provider informs tenant of the following. California law limits your amount of rent can be increased. See section 1947.12 of the civil code for more information. California law also provides that all tenants have continuously and lawfully occupied the property for at least 12 months or more, or at least one of the tenants has continuously occupied the property for 24 months or more. A housing provider must provide a statement of cause in any notice to terminate the tenancy. See section 1946.2 of the civil code for more information. Exemptions to both rent cap requirements and just cause evictions. Housing that has been issued a certificate of occupancy within the previous 15 years. A property containing two separate dwelling units, including ADUs and junior ADUs, that'd be auxiliary dwelling units, with a single structure in which one of the units was owner occupied at the commencement and throughout the tenancy, right? So if you're renting out your ADU, then this doesn't apply, as long as you're occupying the main residence. Single family residential property, including a condominium and units in planned developments, that is alienable separate from the title to any other dwelling unit if the notice below is checked and delivered to the tenant. Notice of exemption. This property is not subject to the rent limits imposed by section 1947.12 of the civil code and is not subject to the just cause requirements of 1946.2 of the civil code. This property meets the requirements of 1947.12 D5 and 1946 E2 E8 of the civil code. And the owner is not any of the following: a real estate investment trust as defined by 856 of the Internal Revenue Code, a corporation, a limited liability company in which at least one member is a corporation. Okay, there's your notice of exemption that should have been provided to the tenant. Additional exemptions only applicable to just cause evictions. Housing accommodations in which tenant shares a bedroom or kitchen facilities with the owner who maintains their principal residence at the residential real property, right? So you're leasing a bedroom to somebody out of your own property. Single family owner occupied residences, including a residence in which the owner occupant rents or leases no more than 2 units or bedrooms, including but not limited to an accessory dwelling unit. Those are additional exemptions to the just cause evictions. Rent cap requirements, certain provisions of Civil Code 1947.12, subdivision B. An owner of real property shall not increase the rental rate for that property more than 5% plus percentage change in cost of living, or 10%, whichever is lower, of the lowest rental amount charged for that property at any time during the 12 months prior to the effective date of the increase. I feel sorry for landlords in California. If the same tenant remains in occupancy over 12 months, the gross rental rate shall not be increased more than 2 increments over that 12-month period. For new tenancy in which no tenant from the prior tenancy remains, owner may establish the initial rate not subject to paragraph 1 of this section. Paragraph 1 is only applicable to subsequent increases after the initial rental rate has been established. So tenant is in the property, tenant vacates, new tenant comes in, you can set whatever you want for that new rent for the new tenant. Just cause reasons for termination of tenancy, at fault reasons, default of payment of rent, breach of material term of the lease described as Civil Code Procedure 1161, paragraph 3, including but not limited to violation of a provision in the lease after being issued a written notice to correct the violation, maintaining, committing, or permitting the maintenance of a nuisance as described of Civil Code Procedure 1161, paragraph 4. Committing waste as described in Civil Code Procedure 1161, paragraph 4. The tenant had a written lease that terminated on or after January 1st, 2020, and after written request or demand from the owner, tenant refused to execute a written extension or renewal of the lease for an additional term of similar duration with similar provisions, provided those terms do not violate 1946.1 or any other provision of the law. Criminal activity by the tenant on the residential real property, including any common areas or criminal threat as defined in Penal Code 422 subdivision A, directed by any owner or agent of the owner of the premises, assigning or subletting the premises in violation of tenant's lease, tenant's refusal to allow owner to enter the residential real property pursuant to a request consistent with Civil Code 1101.5 in 1954 and the Health and Safety Code 13113.7 and 17926.1. Using the premises for an unlawful purchase or purpose as described in Civil Code Procedure 1161, paragraph 4, or when the tenant fails to deliver possession of the residential real property after providing the owner written notice of the tenant's intent to terminate the hiring of real property, or makes a written offer to surrender that is accepted in writing by the housing provider, but fails to deliver possession at times specified in that written notice. So those would be all the at-fault reasons that could cause you to terminate tenancy by just cause reasons, okay? At no fault reasons, so these are not at fault of the tenant themselves. Intent to occupy the residential real property by the owner or their spouse, domestic partner, children, grandchildren, parents, or grandparents, owner, family, move-in. Tenant and owner hereby agree that the owner shall have the right to terminate the lease if the owner or their spouse, domestic partner, children, grandchildren, parents, or grandparents unilaterally decide to occupy the residential property. Owner may terminate the lease at the end of a fixed term or any time during a month-to-month tenancy by giving the appropriate notice. Withdrawal of the premise from the rental market. Owner may terminate the lease at the end of the fixed term or any time during a month-to-month tenancy by giving the appropriate notice. Unsafe habitation as determined by a government agency that has issued an order to vacate or to comply with other order that necessitates vacating the residential property. Intent to demolish or substantially remodel the residential real property. Substantially remodel means the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit that cannot be accomplished in a safe manner with the tenant in place and requires the tenant to vacate the residential real property for at least 30 days. Cosmetic improvements alone do not qualify. Ooh, so much information. Do we have any questions so far? It's making sense to everybody? Okay, moving on to section 3, just cause notices, curable at-fault reasons. Before the owner can terminate tenancy in an at-fault just cause violation that is curable, the owner must first provide notice to cure, giving the tenant the opportunity to cure the violation pursuant to Civil Code Procedure 1161, paragraph 3, right? The tenant has the right to bring rent current, basically. Tenant payments pursuant or stop subletting the property, right? Tenant payments pursuant to no out-fault eviction. If owner issues a termination of tenancy under a no-fault just cause, owner notifies tenant of the right to direct payment relocation assistance equal to 1 month of tenant's rent in effect at time of termination and shall be provided with 15 calendar days of service of the notice. In lieu of direct payment, owner may waive the payment of rent for the final month of tenancy prior to the rent becoming due. This notice shall state the amount of rent waived and that no rent due for the final month of tenancy, right? So that's just helping the tenant move on their way. Keep in mind in here that you can't terminate tenancy because we're selling the property. At no point was that listed under the no fault reasons. Okay, note, other exemptions under the civil code may apply. Additionally, this property may be subject to local rent cap and just cause eviction controls, which may impose additional restrictions. Housing provider is strongly advised to seek counsel from a qualified California real estate attorney who is familiar with the law where the property is located prior to serving any notice. The undersigned acknowledge a copy of this document and agree that the terms specified in sections 1, 2, 3, if checked, and V3 are made part of the lease or rental agreement specified above. So it's important this gets provided with a copy of the rental agreement. In this case, it's just being served for knowledge purposes only. Remember at the beginning, we said, hey, provided for information only. So I would take this same provided for because we're not having the tenant sign it right now. And I would put it down here as well. I would have my buyer initial the pages on this, like the top corner or the bottom corner of these 2 pages, but I wouldn't have them sign this document. So they would sign this tenant, the TOPA form, the tenant occupied property addendum, and then I would have them initial the rent cap and just cause addendum if the tenants are remaining in possession so that they understand that these are the requirements. Make sense to everybody?
Yes, ma'am.
Yes. You're like, I will never sell a property with a tenant occupying it again.
It
Right?
seems like a headache.
It seems like a headache. It's way easier if you're just like, hey, kick them out, right? But it does happen, right? It happens all the time. We have investors looking for investment properties. They're doing 1031 exchanges. And if they can buy a property with a tenant in there that's already paying rent, market rate, that's a good tenant, like even better, because then the property's never vacant. So you will at some point probably come across this. The tenant estoppel certificates is the next one. Let's see, we got 15 minutes. Fabulous. So this was mentioned in that TOPA that the tenant estoppel certificate may be requested, right? It was one of the boxes we could check if the tenant was remaining in possession. I highly recommend that this gets done. Number one, it shows the tenant's willingness to comply with the new owner because the tenant's supposed to sign this. And number two, it's saying that, hey, everybody's in agreement that these are the terms of the lease. So the tenant's name goes up here. Tenant one, right? So tenant goes in here, the premises goes in here. Now keep in mind that you can have a tenant estoppel certificate for every unit. So you could have one for unit 1, unit 2, unit 3, unit 4, right? So you might have multiple tenant estoppel certificates, at which point for the premises, you would probably want to put unit 1 on unit 1 and so on and so forth. There might be a better way to put that. Let's see if we can. It's frozen. That's inconvenient. Let's see if it comes back. Otherwise, I'll have to reopen the screen. There we go. Oh, here you could put under here unit 1. I would put it here, not on the main address, because if we put it on the main address, it's going to change the main address everywhere. So I'd leave that alone. And it's thinking really hard now again. So we'll wait for it to come back. On the second or third line, that's where I would put unit 1 or unit A or whatever the units are that you're referencing on this estoppel certificate. Lease terms, right? To whom it may concern, the undersigned is the tenant of the above premise and makes the following representation. A copy of the lease is attached here too. So I would always make sure that a copy of the lease, if I was a listing agent and tenants are in possession of the property, I would go ahead and provide these up front. And I would attach a copy of the lease agreement to this. The date of the lease, right? You're going to get the date of the lease, the name of the current landlord, name of current tenant, current monthly base rent, when it was paid through, right? So if they paid October rent, it would be paid through 10/31/23. security deposit and any other deposits, right? Because they may have had like a security deposit and a pet deposit or something to that effect. Or maybe they have a water, there's a term for it, but like they've got a fish tank or a water bed or something. Yes, Anastasia.
So there was a couple of times I was showing an investor some some tenant occupied, and they were like, you can't go in there and see the condition of the property. You have to make an offer first.
Yep.
How many people do you know that are willing to do that? Make an offer sight unseen.
Yeah, so most investors are willing to do that. They understand that comes with purchasing of multi-unit properties. And the reason that a listing agent would do that is that here I've got these tenants occupying a property that are probably already a little irritated that it's being sold, right? And we don't want to, on every whim of somebody who wants to see the property, inconvenience our tenants and piss them off to the point they quit paying rent or that they leave during this process of showing the property. So here's what I want in order to be able to show it. I want you to make me an offer on this property. If the offer is acceptable, then we'll make arrangements to be able to see those units, just so they're not like having to show, give notice to the tenants every day that, hey, at this time we're showing the property, at this time we're showing the property. It limits the amount of interruption to the tenants' lives.
Even ones that are vacant? They wouldn't even let us into those.
Usually if it's vacant, they'll let you in. So really it was just a poor listing agent's choice there. Usually if there's a vacant unit, they'll let you go in and see it. If they're not, that's probably a pretty sizable red flag. But then keep in mind too, with your offer, you're going to have that investigation contingency. So you're really out, maybe 30 minutes that it's going to take you to write and submit the offer. And other than that, you're really not out any time, energy, or effort to be able to do that. So you just have to weigh how important this is to your buyer to be able to see the property. But they walk in there, they don't like the condition of it, they can turn around and cancel.
Okay.
Yep.
Thank you. Sorry for the interruption.
No problem. Right. All right. So you're going to get the current rent, security deposit, expiration of current term is going to be in there. Number and location of parking spaces, number and location of storage spaces, who pays utility services, water, is it landlord tenant, electric landlord tenant, gas landlord tenant, waste disposal landlord tenant, gardener landlord tenant, sewer landlord tenant, right? Other, is there something else that's being paid for? Maybe like pool service is usually a common one that you see on there. Landlord tenant, there's a couple lines for other under utility services. Who owns the appliance? The stove, the refrigerator, the washer dryer, the microwave, and other, right? Is it the landlord or the tenants? The tenant represents that the original lease remains in full force and effect and constitutes the entire agreement between the tenant and landlord, except for the following modifications, amendments, addendums, assignments, extensions, and or preferential rights or options to purchase lease, right? So anything that's going to be listed out there. There are no verbal or written agreements or understandings between landlord and tenant with respect to the premise except as set forth above. So everything that's been mentioned, that all the buddy agreements, they're all going to be on number 2. The tenant is the actual occupant and is in possession of the leased premises. Tenant has not assigned, transferred, or hypothecated its interest under the lease. Any construction, build out, improvements, alterations, or additions to the premises required under the lease have been fully completed in accordance with the plans and specifications described in the lease. All obligations of the landlord under lease have been fully performed, and the landlord is not in default under any term of the lease. Tenant has no defenses, offsets, or counterclaims to the payment of rent or other amounts due from the tenant to landlord under the lease. Tenant has not been given any free rent, partial rent, rebates, rent abatements, or rent concessions of any kind except as follows. It should all be outlined there on number 5. Tenant has not filed and is not in the subject of filing for bankruptcy or reorganization under federal bankruptcy laws or similar state laws. Tenant represents that tenant is not in default of the performance of any obligations under the lease, has not committed any breach of the lease, and has not received any notice of default under the lease which has been cured. The correct address for notices to the tenant is the premise unless otherwise shown below. The person signing below represents that he or she is duly authorized by the tenant to execute this statement on tenant's behalf. Tenant understands that a lender may make a loan secured in whole or part by the premise, and if the lender does so, lender's action will be on material reliance on this estoppel certificate, and or a buyer may acquire the premise or building in which the premises is located, and if buyer completes the purchase, buyer will do so in material reliance on this estoppel certificate. Here, the tenant signs it, the landlord signs it, in both of these and dates it. And that's the tenant estoppel certificate. And you get those for each of the occupied units. Any questions about the tenant estoppel certificate? And again, that was mentioned up here on the TOPA form. Section 2, tenants remaining in possession. E3, you could check the box for tenant estoppel certificates, and I would absolutely ask for that to be included, because again, you're getting the tenant's willingness to cooperate with the sale, how excited they are about the sale or how willing they are to cooperate with a new landlord is often outlined there in their willingness to make sure it's filled out and signed. And number 2, you've got the tenant's signature that, hey, we understand the property is being sold. And we understand that, sorry, getting back to that tenant estoppel certificate. Oh, I was down further. And we understand that these are all the terms of the transaction. I just accidentally hit the back arrow. There we go. Right? So that's what this is doing. So I would absolutely include this. Any questions about that tenant estoppel certificate? And since we're on the tenant theme today, we're going to go ahead and cover the key safe and lockbox addendum, just so you know, if there is a tenant occupied property and you are the listing agent of that property, on the residential listing agreement, it gives you a box to check if it is tenant occupied, and that you are to include this key safe lockbox addendum and tenant permission to access the property as part of that listing agreement. This also gets signed by the tenant, so this is super important to have in place. It gives you permission to put a key lockbox on that property. It gives you permission to put a sign on the property, and it gives you permission to access the property. So this is the KLA. It was also revised on 6/23. Everything was because they updated some of the landlord terms in here to other terms. So the undersigned seller, and if applicable housing provider, here's your seller's names go here, owner has entered into an agreement with, here's where the listing broker's information goes. Here's the date of the residential listing agreement. To market for sale, lease, or rent the real property located at, and there's that full address again. Disclosures regarding access to and protection of property. A key safe lockbox is designed to hold a key to the above property, permitting access to the interior of the property by other brokers, and real estate licensees who are participants of the MLS. Authorized appraisers and inspectors, and a company person interested in purchasing, leasing, or renting the property. These individuals may take videos or photographs of the property. Broker does not have the ability to control or block the taking of and the use of images by such persons. That's A. B is MLS rules require a key safe lockbox placed on the property to be an MLS approved access device in accordance with the rules of the MLS to which the listing has been submitted. Generally, an MLS approved access device is one that is specifically authorized by the MLS, or where use of it provides reasonable and timely access to the listed property in accordance with the standards required by the MLS. C is brokers, cooperating brokers, and other real estate licensees. The MLS and Association's Board of Realtors are not insurers against theft, injury, loss, vandalism, damage, or other harm, whether access is a result of the use of the key safe lockbox or other means. Brokers does not maintain insurance to protect owner or other occupants. Okay. D is broker recommends that owner and, if applicable, tenant and other occupants of the property maintain insurance and take all possible precautions and safeguards to protect themselves, other occupants, and visitors, their property and belongings, including cash, jewelry, drugs, firearms, and other valuables located on the property. Right? That's just the disclosure of access and protection. Any questions about that section, section 1? All right, section 2 is owner permission for use of a key safe lockbox. Owner hereby authorizes broker to use a key safe lockbox if the property is tenant occupied. Owner is advised that tenant permission may be required and is recommended. Owner acknowledges a receipt and a copy of this document, and here's where the sellers are going to sign right here under section 2 for permission to use a key safe lockbox. Section 3 is tenant permission, excuse me, to access premises. I am the current tenant of the above referenced property, and I have read the disclosure statements above. In addition to any authority granted in the lease or rental agreement, I agree as follows. Broker may use a key safe lockbox, and broker may show the property as follows. Usually in their lease, it specifies they can show it with 24-hour notice. Okay, so you would check those boxes there, fill in this line here. Number 3, for single family dwellings, broker may post a for sale, for lease, for rent, or sold sign on the property. Okay, we need the tenant's permission to be able to do that. Tenant acknowledges a receipt of a copy of this document. Here's the date and the tenant signatures, and that is the key safe lockbox addendum and tenant permission to access the property KLA form that's referenced in the residential listing agreement. So again, seller not occupy the property, this should be part of the lease. Yes, Anastasia?
What if the tenant refuses to sign that?
And then technically you can't put a key safe or lockbox on the property, and you don't have permission to show the property.
So you're screwed.
Well, technically, again, this goes back to oftentimes the lease agreement. So we're just getting cooperation. We're getting permission of cooperation from the tenant. The owner of the property has the ability to go around this and say, hey, we don't care. We're going to provide access to the property. You technically can't legally put a lockbox on the property, I don't believe, but you should talk with a qualified California real estate attorney on that. But you can still provide access. Their lease agreement specifies, generally speaking, most default lease agreements specify that the owner has the right to show the property for sale or rent with 24 hours notice. So you could just say, hey, we're giving you the notice. We're going to be there at 3 p.m. tomorrow to show the property. Tenant has to cooperate, or now tenant, if they don't, is now in breach of their lease agreement, at which point we read in the rent cap and just cause addendum that's grounds at which the seller or the owner could then terminate that tenancy.
Gotcha. Okay.
Wah, wah, wah,
It
right?
just takes longer.
It just takes longer. And ultimately, you want to try to get that tenant to cooperate, and you understand that it's an inconvenience to them. Like, it's no fun, even as a seller, to show your property and have your life inconvenienced. It's even more not fun as a tenant. Like, you didn't sign up for this, and now this property is being sold and you're being asked to show it. It just is a bad situation all the way around. So you want to try to work with that tenant and like come at it from a win-win situation of, hey, like, are there certain hours, how early and how late can we show the property? Are there certain hours? Do you have kids that nap in the afternoon? Like, we want to try to make this as convenient as possible, but the seller does need to get the property sold. So what would be helpful in making this happen for you, and just coming at it from contribution for that tenant so that we can keep them on, good terms. So yeah,
you're just so knowledgeable. It's just amazing.
But sometimes I forget these things exist. Like Adriana had a listing that had the brother occupying the property. We should have used this because it wasn't the seller occupying the property. The seller had passed away. And then we should have had the TOPA included as part of that contract. So sometimes, even though I know it should be, we still fail. Go, Charles.
No, I was just agreeing. You're very knowledgeable, and I appreciate you.
Thank you. Thank you. Sometimes, I feel like sometimes, like a pastor, right? Sometimes the pastor, if you go to church or have ever been to church, sometimes the pastor gets up there and they preach a sermon and they're like, oh, this was for me, not for you guys. And I feel like that sometimes when I cover these TOPA forms, or these, not the TOPA, but just forms in general in the card library, sometimes it's more for me than for you guys. It's a good reminder. And this is why, it doesn't matter how much experience you have or how long you've been in the business. It's always good to like pop in on trainings and see what's going on, because sometimes you're so set in your ways, you forget things exist, or it's been so long since you've had a tenant occupied property that you forget the things that you're actually probably supposed to do as part of that.
Yeah.
So yeah, there you go. That's all I got for you today. It's 10:02. Look at that. We covered like 3 or 4 forms and stayed pretty close to on time. In fact, we started at 5 after, so we stayed right on time. So I appreciate everyone joining us today. Super fun. Again, if you have any recommendations for future trainings, please don't hesitate to make those recommendations to me. I'm not seeing the little attendant thing pop up in the chat box, but I'm sure Abby has your attendance. But yeah, just make those recommendations. I know we talked about before we got started, while we were waiting for our latecomers to arrive, that it might be good to have a class on the different ways that you can hold title and new build versus resale. What are the differences, what to expect? Maybe even pull a couple of copies of new build contracts so you guys can see what those look like, because it's usually not on the residential purchase agreement. So those recommendations were made. I'll see you next week. We've got we're finishing up our goal setting, or setting ourselves up for success in 2024 next week, because we're rounding out the month. So we'll tell you how to take it from, we took it from a GPS to a 12-week, and then we're going to take it from a 12-week into a weekly action items to help you accomplish your goals. On Tuesday at 10:30, Wednesday at 9, we have time blocking for success. We'll talk about how to do that well and what that looks like. Wednesday, we're covering some HOA forms, your homeowners association forms that should be included or might be included in your transactions if there's a HOA involved. And then that'll be my last training with you guys for a couple of weeks. We will still have some trainings. I'll make sure that schedule gets published, same Zoom link. Abby will be with you guys, guiding you through that, and whoever's teaching those trainings, but I will get that finalized schedule for you while I am out for a couple of weeks with medical stuff with my family. So we'll see you next week.
Thank you. Have a good week, you guys.
Absolutely.
Thank you, Amy. And you said there's nothing in the chat box for the login?
No,
For
there's
attendance?
oh, there it is. Your attendance is now in the chat box. You can click on that, log it, and then also make any other suggestions for future trainings.
Dun, dun, dun. Abby to the rescue.
All right. Fabulous. Thanks everyone for joining me today. I really appreciate it. We will
Thank
see
you.
you next week.